I'm a living, breathing person, human being. For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. I would like to state for the record that I am not a corporation. I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort.
All right, folks, buckle up, because today we are dealing with one of the most out there sovereign citizen courtroom performances I've seen in a long time. And let me tell you, this one isn't about traffic tickets or speeding fines. Nope. This man is standing in the Michigan Court of Appeals trying to dodge one of the most basic responsibilities in life: child support. And how does he plan to do it? By declaring, with a straight face, that he's not a corporation, but a living, breathing human being.
If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth, back and forth, back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people who just represent themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant.
Oh yes, This man really compared paying child support to McDonald's trying to force-feed him a Big Mac without consent. I'm not kidding. That was his analogy. Now, you've probably heard these sovereign citizen scripts before. All the talk about jurisdiction, contracts with the state, and refusing to consent. But in this courtroom, with 3 judges staring at him, the whole routine looks less like clever legal theory and more like a desperate attempt to duck out on his kid. When asked to state his name for the record, he doesn't just say it. No, he launches into this dramatic introduction. I'm the beneficiary of the trust and estate of Mr. Kevin Dwayne Kraft, the legal persona. He claims he's not making a general appearance, but a special divine appearance. Folks, I wish I were making that up. The judges try to be patient. They really do. They explain to him slowly that this is the Court of Appeal.
That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent of any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context. These are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnostic Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
This isn't a trial court where he gets to go back and forth endlessly with questions. Here, you make your argument, the judges listen, they might ask a few clarifying questions, and then they take the case under advisement. Pretty straightforward. But instead of making a clear argument, he dives into his sovereign citizen playbook. He demands to know whether this is a constitutional court applying common law or maritime law. He insists that without his consent, None of this applies to him, and every sentence feels like he's just digging himself deeper into quicksand. Then comes his main point. He claims the state violated his rights by ordering a DNA test. He argues that asking for his genetic material without a warrant is unconstitutional.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Front of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human.
Institutional. Now listen. In another context, that could sound like a serious question. But here, when the issue is determining whether or not you're financially responsible for a child, the court isn't overstepping. It's following the law. That's standard procedure in family court. But he doesn't stop there. No, he starts talking about businesses, contracts, and how the friend of the court is secretly a for-profit agency with a Dun and Bradstreet number. He insists the entire system is a business scam, and that because he never signed a contract, he owes nothing. And that's where you see the heart of his argument.
With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for it incentivizes them to collect more child support. The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And it's basically it's evidence is they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of
yes.
time. We understand that you raise issues of disclosure,
Yes.
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue that, or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.
Argument. He believes that if he just says the magic words, "I don't consent," the entire weight of family law, child support enforcement, and constitutional authority will just vanish, like smoke in the wind. Now here's where it goes from bizarre to downright surreal. The judges, still keeping their composure, ask him to clarify exactly what law he thinks applies. And that's when he drops his grand finale. Your Honors, I am not a corporation. I am a living, breathing man. Just like McDonald's can't force me to eat a Big Mac, the state can't force me into a contract I didn't agree to. Yes, that was his argument in the Michigan Court of Appeals. That child support, the financial obligation to raise his own child, is nothing more than a burger order he never placed. Now, I don't know about you, but when you start comparing your parental responsibility to fast food, you've already lost the plot. And the judges knew it. You could see it in their faces. They've heard every excuse in the book, but this was just another tired sovereign citizen performance with no legal footing whatsoever. The truth is, child support isn't a contract. It isn't a business deal. It's the law. If you bring a child into this world, you're responsible. Period. You don't get to word play your way out of it. You don't get to pretend you're some divine being floating above the rules of society. You pay. And if you don't, the state steps in to make sure that child doesn't go without. But sovereign citizens live in this bubble where they really believe saying, "I do not consent," turns the government invisible. And in this courtroom, the judges made it crystal clear. That's not how the real world works. They let him finish his little script. They asked if he had any actual legal authority to back up his claims, and of course, he didn't. In the end, the court ruled exactly as you'd expect. They upheld the child support order. His claims about contracts, corporations, and McDonald's hamburgers were dismissed as irrelevant nonsense. And just like that, his sovereign citizen fantasy hit a brick wall of reality. But here's the kicker, folks. While he was busy trying to outsmart the system with pseudo-legal jargon, all he really did was show the court and the world that he was willing to fight harder to avoid paying for his kid than to actually be there for his kid. And that's the sad, frustrating truth of so many of these cases, because at the end of the day, sovereign citizen arguments don't keep a roof over a child's head. They don't buy clothes. They don't put food on the table. All they do is waste the court's time, frustrate judges, and make the person spewing them look foolish. So yes, this man thought he could rewrite the law with clever word games. But the law didn't bend. The judges didn't buy it. And his Big Mac defense? It went straight into the trash.